role of conciliation under Arbitration and Conciliation Act. As we know that the term conciliation first originate in Indian Statute Industrial Dispute Act. In Industrial Dispute Act, there is description of conciliation term under section 4, role of conciliator, and under section 12 also power of conciliation officer. The various statutes discuss about conciliation: the Sexual Harassment Act, the MSME Act, the Commercial Court Act, the Family Court Act 1984 discuss about conciliation. As we know that conciliation is a type of negotiation in which a third party assist, help the disputant party to reach a amicable settlement. However, under Conciliation and Arbitration Act, there is description of conciliation under section 30. Provide that the arbiter tribunal may try to have the dispute settled by mediation or conciliation for reaching a settlement. And under part 3, section 61 to 81 of the 1996 Act deal with conciliation. Conciliation. In the conciliation, the conciliator play a more proactive role. He acts as a facilitator, evaluator, and intervener. He can suggest various solutions to the parties. The outcome is a settlement agreement. The settlement agreement reached between the party has the same status as the status of arbitral award, and it is executable as a degree of civil court. Conciliation is governed by Part 3 of Arbitration and Conciliation Act. Conciliation is bound by confidentiality. Extent of confidentiality is defined by the law. The settlement agreement is enforced as an arbitral award. Breach of settlement agreement would be the same as breach of an arbitral award under the Arbitration and Conciliation Act. As we know that in the conciliation, there is a neutral third party, and conciliation is one type of alternative method of dispute resolution. In this process, a neutral third party try to make settlement between the disputants. It can be understood as a process of getting the party to come to an agreement about a common problem, dispute, through confidential discussion and dialogue. It is very similar to mediation. It is voluntary, flexible, and completely at party initiative. Characteristics of conciliation: it is voluntary, non-adversarial, assisted procedure, finality of settlement, confidential. As we know that conciliation is a process which is win-win for both parties. In the adversarial system, parties remain as adversaries, with one party having won and other losing the contest. The win-loss creates a feeling of bitterness and often tends to destroy relation. But in the conciliation, both parties win. No one lose. Therefore, we should encourage the process of conciliation, commencement of conciliation proceeding. The party initiating conciliation send to the other party a written invitation to conciliate under this part, briefly identifying the subject of the dispute. Conciliation proceedings shall commence when the other party accept in writing the invitation to conciliate. If the other party reject the invitation, there will be no conciliation proceeding. If the party initiating conciliation does not receive a reply within 30 days from the date on which he sends the invitation, or within such other period of time as specified in the invitation, he may elect to treat this as a rejection of the invitation to conciliate, and if he so elects, he shall inform in writing the other party accordingly. Number of conciliator. Conciliator number may be 1 and maximum number may be 3 as per section 63 of the Act. As we know that the conciliation start from section 61 to 81, and the important part of conciliation is commencement of conciliation proceeding under section 62, number of conciliators under section 63, appointment of conciliator under 64, submission of settlement to conciliator section 65, role of conciliator 67, conciliator not bound by certain enactments section 66, administrative assistant section 68, communication between conciliator and party section 69, disclosure of information section 70, cooperation of party with conciliators section 71, suggestion by party for settlement of dispute 72, settlement agreement section 73, status and effect of settlement agreement 74, confidentiality section 75, termination of conciliation proceeding section 76, resort to arbitral or judicial proceeding section 77, and the conciliation part is last from section 81. So as we know that conciliation is the process in which third party assists, and with the assistance of third party, the party reach a settlement. A conciliator is also permitted to make proposal for a settlement and formulate or reformulate terms of possible settlement, which therefore show that if the role of conciliator is proactive and interventionist, the mediator or the conciliator play a role in getting the party to discuss their problem and attempt to create a balance which leads to a win-win situation. So role of conciliator. Role of conciliator is given under section 67, in which conciliator formulate and reformulate the term and condition of settlement. Conciliator suggest party. Conciliator gives their opinion. You may go to this way and your problem will be resolved. It may not be in writing. Conciliator suggestion and proposal should not be in writing, but he may give suggestion, and after the observation of party, he may reformulate his suggestion, and after discussion with the party, he may prepare settlement agreement, and this settlement agreement should be presented before the party, and conciliator must authenticate this settlement agreement, and also party should also sign this document so that it is made settlement agreement and it will be treated as a settlement award So in this way, conciliation process is a win-win process in which both party win and no one loses. Thank you.